May it please your lordship. Sorry for indulgence. Since chief engineer is here,
Yeah.
our matter may be upgraded.
Call up item 3.
For admission, item number 3.
Yes, please.
Your Lordship, as directed during my last appearance in the Honorable Court, I have perused the relevant records from the office, and it was found that in 2014, the department had already taken some action against the respondent number 11, the then executive engineer, for issuing completion report before work completion.
2000?
14, sir.
You have a copy of that order?
Yes, sir. The show cause notice was replied by respondent number 11 on 24th March 2014, stating he had issued the completion report not for his personal gain, but in the interest of the work. After considering his reply, the department issued a last and formal warning to respondent number 11 on 30th of April 2014. Your Lordship, the competent authority for taking any further action to the respondent number 11 is the government. As such, I have forwarded the matter to the government for further necessary action and direction by letter dated 30th of January 2023. I also pray before your Lordship to kindly dispense with my personal appearance.
You say that the government is the competent authority to take steps against the executive engineer.
Yes, sir. Your Lordship.
Then what about this warning letter which was issued by the chief engineer?
So that was after decision was taken after his reply to the show cause notice served to him.
No. If the competent authority is the government, then the government should have taken the steps. The chief engineer himself issued the warning letter.
Yes,
That's
madam.
beyond your competence. Isn't it?
Your Lordship, he has already been served with a warning letter,
That's why.
and any further action.
You
yeah.
said that the government is the competent authority to take action against the executive engineer,
Yes, my lord.
basing on the reply given to the show cause notice.
Yes, my lord.
Now, the government is to take action against the executive engineer. But what has happened is the chief engineer has issued a warning letter, and there's no reference to any government letters in this warning letter. If there's a reference to government letter, then you can say that on the basis of government instruction, chief engineer issued the warning letter. But then government has taken no action. Yes, Mr. L.T. Sanctum.
Your lordship may be pleased to pass a directive to take necessary actions on the area of executive action.
I think it is not the job of the court to issue directions to the chief engineer to take necessary action against the executive engineer. What we are saying is that actually a work completion order was issued even before the completion of the work. So it is for the department. And if the chief engineer says that it is the government, then my lord is saying that actually the chief engineer has no power to issue this warning letter. So the chief engineer is contradicting himself. He says that the government is the competent authority. On the other hand, the warning letter has been issued by the chief engineer.
Yes, Mr. Additional AG.
Your Lordships, the Chief Engineer has stated that for necessary action to be initiated against the respondent number 11, he has forwarded the letter to the government on 30th January 2023.
31st.
30th.
30th January 2023, Your Lordships.
Where is that letter?
Your Lordship, it is in the first page of the.
First page.
That is why I'm saying the first page is 31st January.
Yes, sir.
Yes, Your Lordship.
Okay. Heard Cindy Younger and the counsel for the petition. Stop. The chief engineer. PWD within bracket R&B is present in court as directed by this court earlier. Stop. He has furnished a letter to 31st January 2023. No, so cancel it. The chief engineer PWD R&B submits that after the issuance of the false completion certificate by the concerned executive engineer oblique respond number 11, comma, the chief engineer PWD R&B had issued a show cause notice dated 20 March 2014 to the respondent number 11. Stop. Pursuant to the show cause notice, the respondent number 11 met his reply on 24/3/2014. Stop. It is the submission of the chief engineer PWD within bracket R&B that the competent authority to take action against the executive engineer oblique respond number 11 is the government and not the chief engineer PWD R&B. Stop. However, from the documents produced before us, it appears that it is seen that the chief engineer PWD R&B had issued a warning letter to the respond number 11. Stop. Considering the submission of the chief engineer PWD R&B, and if it is the government who is the competent authority to take steps, to take action against respond number 11, comma, we see no documents, documents before us as to what steps the government has taken against respond number 11. Only a letter dated 31st January 2023 is produced before us, written by the Chief Engineer PWD R&B and addressed to the Commissioner and Secretary, to the Government of Nagaland, Works and Housing, Nagaland, Kohima, for taking necessary action in terms of the show cause notice and the reply made thereto. Stop. The Commissioner and Secretary to the Government of Nagaland, Works and Housing is directed to file an affidavit indicating what steps have been taken after receipt of the letter dated 31st January 2023, written by the Chief Engineer PWD R&B. Stop. Let such affidavit be filed within a period of 1 week from today. Stop. List the matter again on after 1 week will be what? Please, 10th. You want it listed on 22nd February. Stop.
Please, my lords.
Yes.
My lords, I have filed an affidavit on 30th of January.
I've seen that.
My lord.
The personal appearance of Chief Engineer, PWD, is dispensed with for the time.
My lord, 1 week's time may be little short.
I said 1 week, I have fixed the date on 22nd.
22nd February.
Oh, my lord.
Yes, so you're getting 3 weeks.
Oblige, my lords.
For admission, item number 1 and 2.
Since you are filing your written arguments, CP, let us make your reply shorter.
That is what I'm thinking also, Lordships.
Since your
Since-
reply is coming, your argument is coming before us in written.
We have entered into 5th day,
Yeah.
and Lordships are patiently hearing. We are grateful for that. And as far as possible, I will try to shorten my reply, and I will reply only to the points which has been raised. That too, as far as possible, I'll make it brief.
As far as possible.
First, Lordships, there are few points which are common to both. And so far as the judgments are concerned, I would wish to just place the citations, page numbers, and the paragraphs instead of spending time in reading the judgments. So I will prefer to do that. Only on the submissions which has been made, I would like to reply on those points. There are some common issues which I would like to reply commonly. And first, let me respond to the submission of the respondent number 1 and Speaker Lordship. My learned friend started his submissions with an argument that for amending the enactment legislation, only on 2 grounds judicial review is possible. That is the legislative confidence and the violation of fundamental rights. Only on these 2 grounds, the judicial review is possible. So far as the legislative confidence is concerned, from the very first day, I have been considering that, yes, I am not saying that they do not have the power. They have ample power. They can do it. So I'm considering that point. With regard to the fundamental rights, I am also conceding on that point, yes, it is correct that when there is fundamental rights, then definitely this honorable court can interfere. Judicial review lies when there is violation of fundamental rights. Therefore, it is my duty to prove that what fundamental rights have been violated and how it has been violated. Therefore, with regard to the second one, that is judicial review is possible when there is fundamental rights. On their submission, I'm also supporting their submission that yes, it is correct that when there is fundamental rights, judicial review lies. And coming to our case, judicial review would lie. And most of the judgments which my 2 learned friends have relied upon are cases where there was no order or direction from the honorable court to make the legislation or discussing about the issue. Here is a case. Our case is a case which has already been argued and a conclusion, a verdict has been given by this honorable court on that particular issue and on that particular point. And the direction of this honorable court is very clear. The respondent number 3 cannot come to the Cadre. That was a clear finding. And that was the issue in the earlier, that is WPC number 323. In short, we are referring 323 of 21. So that was the issue, and that has been decided. And the court has given certain direction, observation, while granting liberty to the state respondents to frame the law. So whether that has been followed or not, that will be relevant. And so far as our case is concerned, the decided cases which has been referred to by my two other learned counsels are cases where there was no earlier litigation with regard to the amendment of the rules. But so far as our case is concerned, there has been an earlier litigation where a categorical finding has been arrived by this honorable court. Therefore, all the rulings where the two principles has been relied upon are not applicable so far as our case is concerned, because the facts of our case and the facts in those cases are totally different. If the cases are similar, facts are similar, then yes, similar principles can be applied. But in those cases, it was pertaining to some other cases, other issues where there was no direction from the court. So when there is violation of fundamental rights, definitely this honorable court can interfere. The second submission of my learned friend was confining to amendment of Rule 9 and Rule 15. Both are little related in the sense that Rule 9 is pertaining to the contract appointment and Rule 15 is about the fixing of 65 years for contract appointment. So on these 2 points, I would like to make a command reply in response to this. Can you come to the writ petition, page number 96? Of the writ petition, page 96 to 101. For two purposes, I am referring to these documents, Lordships. One is this law, this enactment is in contravention of the Nagaland Retirement from Public Employment Act, by which, and the new amendment has given indirect employment contrary to the law. And when the enactment is contrary to any law, then it will violate Article 13 of the Constitution of India. Other day, my learned friend Akamasa has referred to Article 13 by saying that Article 13 talks only about the pre-constitutional laws. But in my respectful submission, it is not so. That is not correct. Yes, Clause 1 talks about pre-constitutional laws. Clause 2 talks about the existing laws and the future laws to be made by the state. The third one is with regard to the definition, Constitution. I would like to refer to the Constitution because this is very important so far as our case is concerned. There is violation of fundamental rights, and the law which has been made is contrary to the existing law.
Where's the Constitution? He's just sleeping, no?
Yes, Lordships. Article 13, laws inconsistent with or interrogation of the fundamental rights. All laws enforced in the territory of India immediately before the commencement of this Constitution, insofar as they are inconsistent with the provisions of this part, shall, to the extent of such inconsistency, be void. That is talking about the pre-constitutional laws. Clause 2, we are concerned with 2 and 3. The state shall not make any law, shall not make any law. It talks about the future laws, which takes away or approaches the rights conferred by this part, and the law made in contravention of this clause shall, to the extent of the contravention, be void. There is already a law, that is the Nagaland Retirement from Public Employment Act, and the new amendment has made a law which is contrary to the Nagaland Retirement from Public Employment Act. Therefore, so far as the inconsistency is concerned, it should be declared as void. And Article 13 is a fundamental right. And coming to the definition, Lordships, Clause 3, in this article, unless the context otherwise requires, law includes the ordinance, order. I'm relying on this order. Order means order passed by this Honorable Court is an order under Article 13 of the Constitution of India. By law, rule, regulation, notification, custom or usage having in the territory of India the force of law. And B, because once we read B, slight confusion may be also created. That is why I want to clear this. Clause B, laws enforced includes law passed or made by the legislature or other competent authority in the territory of India before the commencement of this constitution and not previously revealed. So by reading this clause, it may appear that it talks about the pre-constitutional laws. Yes, come to clause 1. Yes, clause 1. All laws enforced. Laws enforced in clause 3, subclause B, talks about clause 1, the laws enforced. That means clause B is relevant with clause 1 of Article 13, and we are not concerned for that. What we are concerned here is clause 2. And now that the enactment is contrary to the provisions of the Constitution, Article 13, therefore, it is liable to be interfered with by this Honorable Court. State has to make the law inconsistent with the law, and it should not make law contrary to the law. And if any provision is contrary to the existing law, that should be declared as void. So, I hope I'm clear on that, Lordships. Now, coming to the third submission. Lordships, before that, I was referring to page 96 of the writ petition. I have just skipped that. Page 96 to 97 and 101. These are all orders issued by the Nagaland Legislative Assembly constituting the Cadre Review Committee for streamlining of the cadres. Now, in all these orders, 30th September 2020, next page 97, 3rd October 2020, these are all passed and issued by the Commissioner and Secretary, Nagaland Legislative Assembly. And this person has been retired from service on completion of 60 years on 30th May 2020. After his retirement, another indirect employment. For two purposes, I'm referring to these documents, Lordships. One purpose is an officer who has already been retired from active service is made to be discharged, made to be in the active service again by way of this. Documents are very clear. He is exercising the power of Commissioner and Secretary, who is the head of the department in the Nagaland Assembly Secretary. After retirement from service. So, the Nagaland Retirement from Public Employment Act has become mockery. And other day I have referred that this act is applicable to the Nagaland Legislative Assembly also. That is one purpose, Lordships, that after retirement, he is again exercising in the active employment, exercising the power of the Commissioner and Secretary, as if he is not retired. So that is totally contrary to the Nagaland Retirement from Public Employment Act.
Another purpose of referring to these documents is, Lordships, these orders, starting from page 96 to 101, these are all circulars, office memorandum, yes, circulars and office memorandum. This is issued by an authority. My learned friends, they were making a submission that, look, Nagaland Legislative Assembly, especially this post of secretary, is equivalent to the post of chief secretary, holding a very responsible and important post. And that officer has issued these circulars and office memorandums. For what? For what purpose did it was issued? It was issued for the purpose of Cadre review, to review the cadres. And now that we have challenged, filed this writ petition, and in the writ petition we have taken a contention that, look, Cadre review has been already constituted, and for Cadre review, it is under examination by the committee. How come, without considering the report of the committee, you have just hurriedly amended the rules? That was the contention we have taken. In order to defeat that, they have already cancelled all these circulars and office memorandums by one stroke of a pen. This is not required. Then my only question is, Lordships, to examine the reasonableness and the arbitrary action of the respondents. Why and for what purpose you have constituted this, issued these circulars and office memorandum? Are these circulars and office memorandums are not issued under an authority of law? Or these circulars and office memorandums are issued just to cancel by one stroke of a pen that, oh, this is not required, just because we have challenged and questioned about this? Is it not questionable? Is it reasonable? I'm questioning that, Lordships. Lordship may consider all these aspects, whether it is reasonable, arbitrary, exercise of power or not. All these orders are issued by an authority for a purpose. And saying the developments, it is just cancelled. Just for cancellation, you have issued this. These are questionable actions, Lordships. Let me switch over to the third submissions, Lordships. Rule 10, streamlining of the cadre. If I have understood correctly, and I believe I have understood correctly because it is already under record, in the process of his submission, my learned friend has made a submission that, look, we have amended this provision, Rule 10, A and B. All rule has been deleted, and the two new clauses have been added for opening promotional avenues for other cadres. Clearly, clear submission for opening promotional avenues. Okay, I'm not submitting that they cannot do it. They can do it. But if you want to bring them to the cadre, since respondent number 3 is holding an upgraded post personal to the incumbent, you create a post and then bring her also. And you create a post for the OST to speaker, which is only meant for the stenos. You make it equal also. Doesn't matter. But by creating post, without creating post, you are just issuing a tricky amendment saying that there can be no distinction of cadres between the cadres above the joint secretary. This is highly questionable, Lordships. Without creating the post, how you can bring to the cadre? At least this honorable court said that she cannot come to the cadre, she is not holding a cadre post. Clear finding. Then, by the amendment, they have made it nullified, then finding verdict given by this honorable court. Next submission of my learned friend was by referring to Supreme Court judgment 2019, 19 ACC, page 87, on the point of re-employment, which is within the power of the executive. Re-employment, because to justify the amendment by which after 60 years re-employment was made possible, But then in other cases, yes, other states, they may not have any retirement act. They can do so. But then, so far as we are concerned, we have an act, we have a law, that is Nagaland Retirement from Public Employment Act. After 60 years of age, re-employment is not made possible by the act. But they have made it possible. We are questioning that. And the citation which he has relied upon is not applicable. So far as our case is concerned, this is absolutely irrelevant. Now, by referring to a Constitution bench, 1967, Supreme Court, 1910, paragraph 7 and 8, to show that the government's power to cure defect if the role is silent. In other words, it is the prerogative of the government to fill up the gaps if the role do not take care of some problems. So if there is such situation, then yes, government has the power to do that. That is possible in a situation. If you want to cure any defect, yes, you can do it. But so far as bringing to the Cadre is concerned, or making it equivalent so as to hold the post of secretary, which was earlier held by the third Schedule A officers, then without creating the post, it cannot be possible. Without creating the post, by making the post equivalent, no distinction, not equivalent also, distinction. There can be no distinction above joint secretary. By taking advantage of that, they are trying to show that officers from the other cadre has been brought to the cadre. Now, next submission was on the point of Cadre Review Committee, CRC in short. Whether the report of the CRC, what is the value, whether it can be acted upon by the government, all these things. So I have referred to page 96 to 101 about the constitution of the committee. Now, the Assembly Secretariat, Nagaland Legislative Assembly is the lawmaking headquarters. All those are being met in this headquarters. And we have a case of, we have the issue of lawmaking problem in the lawmaking headquarters. Considering the post held by considering the responsibilities discharged by the secretary, like my learned friends, both of them have mentioning about the importance of the post, equivalent to the chief secretary. Yes, I respect that. Such an important post, going by this rule, this is just a food for thought, because this will be relevant. OST to speaker. It is a post held by the stenos, and it was created only for the stenos. And how a person reach this level? Since the steno grade is, number of employees are very limited, at some stages, senior stenographer, it is asymmetrical, the sanction post. In the lower cadre, it is less. In the higher cadre, more posts are there. So in 16, 17 years' time, one can reach from junior stenographer up to the rank of OST to the speaker. Then, since if going by the rule, it was made possible, OST to the speaker will come as the secretary, and every time the gatherer from this steno will come and occupy this post. This has not happened yet, but by implication of law, this will happen. This is going to happen. I'm talking about the reasonableness. And in the general gatherer, the sanction posts are parametrical. They are large in numbers. Most of the officers, they are retiring in the section officers, deputy secretary, and secretary. Very few officers reach the top of joint secretary, additional secretary, who can be promoted to the post of secretary. And after joining in the service of this general cadre, they will be sent for training after training, because a lot of works are technical in nature, legislation and all these things. They are sent for trainings. They are trained in that line in the administration of the Assembly Secretariat Service. Stenos, dictation are given, they are diving, and then they will go up to the OST to the secretary, and they will come and become the secretary. Every time the OST to the secretary will come, to the speaker will come, and go by the post of secretary. This is how they have met. This will happen after a few years only, if it is implemented, if it is kept like this. And the officers in the general cadre, there are large numbers. The employees in the steno wing are very negligible, so before 20 years of service, they will reach the OST to the speaker. Every time they will reach, and then they will come and occupy that post. This is how they have met the rules, lordships. That is why we are questioning. This is unreasonable. Therefore, it has to be interfered with. Next point was whether amendment is violative of the judgment dated 12/5/2022. To support this, he has relied on one judgment, a few judgments, I should say. 1997, one is CC 326, paragraph 16, to show that it is open to the legislature to remove the defect. To that extent, I would also admit that yes, legislature has the power to remove the defects, but such defects can be removed only in accordance with law. And that is what the judgment of 12/5/2022 says. But they have not acted in accordance with law. Another direction was to take into consideration of all the stakeholders. Yes, the interests of respondent number 3 was taken care of very much, but the interests of the petitioners have not been taken care of. Therefore, it is contrary and just opposite to the finding passed by this honorable court, lordships. In this connection, I would like to refer to one of the judgments. This is also a constitution bench, AIR 1978, Supreme Court 803. Whether by defying the court order, legislation can be passed, and if any law is passed, whether such a law can be valid or not. I am referring to only 3 paragraphs, paragraph 4, 8, and 9. Paragraph, sorry, lordships, paragraph 4, 6, 8, 9, and 21. That's your lordship, correct? May I read paragraph 4? The statement of objects and reasons disclose all the purpose of the Imbued Act was to undergo settlement, which had been arrived at between the corporation and class 3 and 4 employees on January 24 and February 6, 1974, and actually recognized by the order of Calcutta High Court. Or should I just skip reading to save time, lordship? Otherwise, we may have some problem if we cannot finish it, lordship. Paragraph 4, 6, 8, 9, and 21. There, if a legislation is done contrary to the order passed by this honorable court, then that can be in effect. By circumventing the court order, they have met the rule. Therefore, it is a fit case to be in effect with. Next submission of my learned friend was by referring to a judgment of this honorable court, 2016, 16 ECC 101, paragraph 7, to show that the motive not amenable to judicial review. So, since he was making a submission that since we have question about the motive, what we were thinking, visualizing, they are saying all these things. But Lordship, it is not only motive. See how they have done. The present Secretary of the Assembly, the current charge has been given to the respondent number 3, basing on the new amended rules and by taking some provisions from the old rules. Action speaks louder than words. It is not only thinking, but they are acting. In any case, under any circumstances, they want that the respondent number 3 should be brought into the Cadre. Even if the court says that she cannot come, they are bringing it. That is how the law has been made, Lordships. Now, next judgment was on Article 187, Clause 3, 1997, 3 GLT, 320. This has already been referred in the other litigation also, 323. And then this Honorable Court has also given the verdict. So it may not be relevant. And next judgment was 2003, 11 SCC, 614, paragraph 45. Mere hardship, not a ground to interfere. In this case, Lordship, it is not a mere hardship, it is violation of fundamental rights, not just a mere hardship. Therefore, the citation which my learned friend has referred to is irrelevant. We are talking about violation of fundamental rights. Now, let me come to the submission of my learned friend for respondent number 3, Mr. Taka. His first submission was on the point of 1966 rules to show that under 1966 rules, there was no distinction. All were treated equally. There were no different schedules. That was the submission. One thing which I do not understand on that submission is, by referring to that 1966 rules, what do you mean to say? Since there was a rule without schedules, without distinction of cadres in 1966, that rule should be applied now? Or by relying on these rules, what do you want to say? What do you mean? That is my question. Yes, there was a rule of 1966. Thereafter, 1999, rule was made in 2005, also amended, and 2012. All along, we were governed by the service rule, terms and conditions laid down in the service rule. At no point of time she has challenged all those rules. Therefore, by relying on 1966 rule, how are you benefited and what do you mean to say? Under present amendment, it has no relevancy so far as 1966 is concerned. And same submissions were made in 323 of 21 also. Earlier litigation, same submissions were made, and this Honorable Court has arrived to a finding from paragraph 22 to paragraph 28. Clear finding. This Honorable Court has referred to all the rules starting from 1966, and they have not challenged that finding also. I was making a submission that respondent number 3 is not in the Cadre. He is not yet in Cadre also. And she is holding an ex-Cadre post personal to the incumbent. That was my submission. Both my learned friends, especially my learned friend Mr. Taka, has responded that they are saying that she is not in the Cadre. he has objected to my submission that I said that she is not in the Cadre. He is objecting to that. They are submitting that I'm not in the Cadre, but I'll show. But as of now, they have not shown whether she is in the Cadre. If so, how she has been brought to the Cadre? By which order? Let them show. Till date, they have not shown. And they have not made any submission also that I'm also in the Cadre. Then, her position is uncertain. I do not know where she stands. The only one thing I know is she is holding an ex-Cadre post, upgraded personnel to the incumbent in the rank of additional secretary. To that extent, I know. Rest, which post she is holding, I don't know. And so far as Cadre posts are concerned, it is under Third Schedule Act. She may have been made, there can be no distinction, so she may have been made equivalent by using that no distinction word. But which post she is holding now? Which substantive post she is holding? A Cadre post. Let them say. She is not in Cadre till date. The substantive post in the transport wing is only up to post of transport officer. And her upgradation order is very clear that the moment she goes, then it will go back to the post of transport officer post. That is a sanction post. And after upgradation of the post, she was brought in to the Cadre. That was challenged. This honorable court has cut that. No, you are not in the Cadre, you cannot come. By the new amendment, it was made possible to come. Whether it is possible or not, I do not know. But then Rule 10 says that there can be no distinction above the post of Joint Secretary. Only that much. Then how she can come? But then she has been asked to hold the current charge even now also. Now, third submission was, liberty was granted by the judgment and order dated 12/5/2022. Therefore, basing on the judgment, basing on the liberty granted by the court, the rule has been amended to cure the defect. That was the submission. So as to remove the hardship, the amendment has been done. One thing my learned friend has overlooked that, I believe, that is to remove hardships. It is under the rules. In a just and equitable manner. And that is very reasonable. In a just and equitable manner. Justice should be done to all. Equality principle has to be maintained to all. Not preferential treatment, not that the preferential treatment should be given to XYZ. And the respondent, by way of this amendment, they have given a preferential treatment to respondent number 3 only. No others. Now, and they have not followed the principle of in a just and equitable manner. The requirement of rule is that. It's clearly laid down in the rules. To save time, I'm not referring to all this. The fourth submission of my learned friend was, out of the two amendments, 2005 and 2002, both the rules has been declared up an issue by judgment and order dated 12/5/2022. That was the submission. And he went on to the extent of saying that the only valid rule is the rule of 1999. That was the submission of my learned friend. That is not a correct submission in the sense that the judgment and order dated 12/5/2022 has been passed on due consideration of the rules of 2012 amendment. Clear finding of this another court is there. Kindly see page 66 to 68. Whether I'm making the submission in the year or I'm making submission on the basis of the records. Page, paragraph 24, page 66 of the writ petition. I will refer to two paragraphs only. My learned friend was insisting me to read the other day the paragraph 25. I was thinking that the more I read the judgment, the more it will go against the private respondent number 3. Paragraph 24, page 66. May I read, Lordship? What can be seen from the above abstract is that, as per the Rule 10, Clause P, irrespective of the relativity of the post, intertransfer between the various schedules in the event of similar scale between the cadres is not permissible. Clear finding. With the insertion of these provisions, the incumbents in the post of DTO or ATO, or for that matter, transport officer, having placed in third schedule D, cannot be considered for transfer and promotion against any of the posts mentioned in the other schedules, and particularly against third schedule A for the purpose of present case. What was relatively not clear and not certain in the principal rule of 1999 and the first amendment of the year 2005 have been made clear by the second amendment made in 2012. The respondent number 3, as pointed out by the petitioners, has been enjoying promotions from the post originally held by her as ATO after the same was upgraded to the post of TO, and thereafter, with similar upgradation to the senior TO, joint secretary, and additional secretary. Here, with similar upgradation means all upgradations were personal to the incumbent. The other day, I have placed the orders how she was upgraded from one post to the another. Such upgradation and promotion made in favor of the respondent number 3 has, however, been made personal to her, and the post is to be automatically reverted back to the original post once she vacates the said post. According to the petitioners, that is why they have not challenged the promotion of the respondent number 3, as her promotion was personal to her. What has caused the dispute now is the issuance of the Imbued Office Memorandum and the Imbued Notification, regularizing the respondent number 3 as additional secretary against the sanctioned post of additional secretary. 25. The rules of 1999 was framed in exercise of the powers conferred by Clause 3 of Article 187 of the Constitution of India by the Governor of Nagaland in consultation with Speaker of the Legislative Assembly. Rule 24 of the said rules provides for repeal and saving. It states that the rules of 1966 has been repealed by the said rules, and that all the orders and actions taken prior to the enforcement of the rules in respect of matter for which there was no specific provisions in the rules shall be deemed to have been validly made or taken. Therefore, the services of the respondent number 3 came to be governed by the rules of 1999. Rule 10 of the rules of 1999 states that the qualifications for recruitment and promotion to any post or class or clause shall be such as specified in third schedule. Although the schedules does not provide for categorization of the post under the Assembly Secretariat, but the post of ATO has been mentioned separately, and that is not a federal post for promotion to any higher post, grade, or post. This is very, very important. The post of ATO has been mentioned separately, and it is not a federal post for promotion to any higher grade or post. As for the post of Assistant Superintendent, ATO, ARO, they are mentioned as the federal post for promotion to the post of Superintendent, Committee Officer, Research Officer in the third schedule, and further, the post of Superintendent, CORO, has been provided as the federal post for promotion to the post of Undersecretary. Therefore, there is clearly a distinction drawn between the post occupied by the respondent number 3 at the relevant time, ATO, and other posts in the general category such as ACO, ARO, or Assistant Superintendent. So, clear finding has been given by this Honorable Court on this particular point. Let me switch over to the next submissions. My learned friend was referring to page 33 of her affidavit. That is page 33. Those show about some file notings. That speaker at one point of time was of the opinion that so and so, this, how this post was created, all this. Now kindly come to page 75 of the writ petition. Paragraph 34. May I read, Lordships? In case of the state of Manipur and others versus Surjakumar Okram and others Sobra, the Apex Court held that an unconstitutional law, be it either due to lack of legislative confidence or in violation of fundamental rights granted under Part 3 of the Constitution of India, is void of an issue. In the case of Shanti Sports Club and so, Apex Court held that noting recorded in file is merely a noting simpliciter and nothing more. It merely represents expression of opinion by the particular individual. By no stretch of imagination, such noting can be treated as a decision of the government. Even if the competent authority records its opinion in the file on the merits of the matter under consideration, the same cannot be termed as a decision of the government unless it is sanctified and acted upon by using an order in accordance with Article 77, Clause 1 and 2, or Article 166, Clause 1 and 2. Now, if we are to consider the file notings of the speaker, which was given at that point of time, two things are also mentioned. Post-creation, Cadre review in their affidavit, the speaker's noting. So, post was not created. So far as Cadre review is concerned, from time to time they are constituting it. Very good. That is for a good cause, for the welfare of all the employees. To act in accordance with law is such a procedure, where the petitioner is, respondent number 3 is also included, members of the petitioners are also there. So that the entries of all can be examined and considered by the committee and submit a report, and a decision will be taken by the competent authority. That is in accordance with law, not in the manner that has been done in the present case, Lordships. Now, the sixth submission of my learned friend was, on earlier occasion, she filed a writ petition, namely WPC number 20 of 2021, seeking for a mandamus from this honorable court. And this writ petition came to be disposed of on 9th of July 2021, directing the respondents to consider her representation. All trouble started from this writ petition. Direction was issued on the day of motion. It was disposed of, directing the speaker. The counsel for the speaker was also appeared on that day, on the day of motion, and made the concession that yes, we will consider and it can be disposed of. That was disposed of on the day of motion. And hurriedly, they have done it by bringing the respondent number 3 to the general cadre. And basing on the Rule 19 and 24, and also in exercise of power under Article 187. My learned friend, Mr. Taka Masa, has said that, look, earlier notification of 1st November 2021 was issued by the authorities by invoking the powers under the rules, but not under Article 187. Therefore, this honorable court has interfered with. That was the categorical submission.
Lordship, sorry for intervention. I'm confused whether it is a rejoinder submission or fresh submission.
Submission. I'm replying
My lord,
to what he has submitted.
whether it is a rejoinder or is being the.
I'm replying.
Phrase separation.
Replying to what he is
afresh
submitting.
all over again. It's 1.5 hours we have listened.
On consideration of the direction passed by this Honorable Court, he has submitted that notification 1/11/2021 has been issued by the authorities. That is what he has submitted. Now, I'm replying on that. I would like to refer to a judgment. 2005 ACC 728, paragraph 18.
Just give the gist, we'll read it.
Well, it says, next page, page 736. 1, 2, 3, 4, 5, 6, 7. Seventh line. The sentence starts with this, however, does not, in our opinion, confer any right on the petitioners to seek a mandamus for encadering those ex-cadre temporary posts, for any such mandamus would be run counter to the statutory provisions governing the creation of cadre and fixation of cadre strength. The basis of the Lordship can examine that paragraph 18. This judgment has clearly replied the submission on the ground of mandamus, how she has demanded the mandamus, and how this Honorable Court has granted, and what circumstances it was granted. That has been replied by this judgment of 2005 ACC. The next submission was referring to the geology and mining, that there are different cadres that has been merged in the higher level. That is possible not only in the geology mining department. There are so many departments under the state where in the higher level meeting point is being met. But those cases are all in the cases where there are sanction posts. Here, no sanction post is available so far as our case is concerned. And there are two posts in our case which are in the higher level. One is OST to the speaker, that is created only for the stenos. The other post is additional secretary, transport, which is upgraded personal to the incumbent, with the condition that the moment it vacates, the post will come back to the post of transport office. So that is clear finding on this. Orders are very clear on this. Now, the next submission was OST to speaker was not implemented as a party. How, in what context is this relevant, I don't know. But then that was the submission. The respondent number 5 was also not implemented as a party respondent initially when the writ petition was filed. Why? Because we are not aggrieved. We have no grievance against respondent number 3, but our grievance was against the actions of respondent number 1 and 2. Therefore, we have implemented only respondent number 1 and 2. But respondent number 3 came forward that I'm also an interested party. So by an order of this Honorable Court, she was implemented as a party. If the OST to speaker is aggrieved, she could have come like that of the respondent number 3, but she has not come before this Honorable Court. Maybe she is wiser that way. Now the next submission was referring to the pleadings in the writ petition, that there is no pleadings about violation of any fundamental rights. That is not a correct submission, because if Lordships look at paragraph 18 of the writ petition, at page 13, we have clearly stated about the violation of Article 14 and 16 of the Constitution of India. Therefore, the submission to the effect that there is no pleadings about a violation of any fundamental rights. One is expected to know what are the articles which are coming under the fundamental rights. There is pleadings. Now, next submission was referring to page 38 of his affidavit of respondent number 3, to show about the assignment of duties, that I have been working this assignment, she have been working that assignment, all these assignments. Lordships are well aware. So far as assignment of duties are concerned, it is the prerogative of the authorities, by discharging a particular job, what legal right an employee confers to claim a particular status, that since I have been discharging these duties and responsibilities, I should be included in this. There is no basis on such assignment of duties to claim a legal right basing on the discharge of duties. This is the prerogative of the authorities. I believe this honorable court may not say that assigning that works to so and so is reasonable. This assignment should not be given to XYZ. That may not be proper. Therefore, this is the prerogative of the authorities to assign any particular works to any individual that do not confer any legal right to any of the employees by giving some particular assignment to a particular officer. And if the respondent number 3 is aggrieved by not bringing her to the Cadre, she could have challenged like that we are challenging. Next submission was on the point that all along we were treated equally. Therefore, even now also we should be treated equally. That was the submission. If they are treated equally, very good, very well, and that should be the spirit. But by treating them equal, what legal right, a special preferential treatment, the respondent number 3 will acquire by treating equal. And my learned friend has referred to page 76 of his affidavit, annexure O, page 76, so as to show about the upgradation of a post in respect of T. Nembimong Lutha, page 76. Upgraded to the post of additional secretary, library, because library is also, there is no post in the higher level. Therefore, this was also upgraded. This clearly shows that there is no sanctioned post and the officer was not holding a sanctioned post. Therefore, upgraded to the grade of additional secretary, personal to the incumbent, with a clear stipulation in the bottom of the order, the post will automatically stand reverted to its original post of senior librarian as and when the present incumbent vacates the post. Similar stipulation in respect of the private respondent also. So, he was not holding a Cadre post. By referring to this document also, this is of no help to the petitioners. Rather, it goes against her. They were all holding outside the Cadre, but in order to keep benefit, they were upgraded. That is to do justice. They are getting equal pay in the rank of additional secretary. So how, in what manner the respondent number 3 is deprived when similar pay is given? Or she wants that she should come to the general Cadre and then exercise her power, like that she is doing now. Again, my learned friend has referred to page 121 of my reply. Affidavit in reply of respondent number, the petitioner against the respondent number 3. 121, by referring to this order of 25th October 2017, from this order, my learned friend tried to show that, look, Cadre Review Committee has already done this, and now that they have done, so whatever remarks, whatever Cadre Review Committee was required to do, they have already done. But then, as I have been referring to your lordships, from page 96 to 101, in the subsequent years, that is 2020, starting from 2020, several orders were issued by the authorities constituting the Cadre Review Committee. Therefore, the discharge of duties way back in 2017 cannot be the end for the Cadre Review exercise. It is still a continuous process, and it was there. But it was, as I was submitting, it was already cancelled for the reason best known to the respondents. Now, few common reply, that is under submissions made by my learned friend, few common reply on the fundamental rights, that there is no violation of fundamental rights. What fundamental rights have been violated? That was the common submission by both the councils, and unequals have been made equals. So this point, this argument has been advanced by both the learned councils, even before, in the earlier litigation. Can we come to paragraph 11 of the judgment at page 56 of the writ petition. Right to be considered is a fundamental right. They are saying that there is no fundamental right violated. But our right to be considered for promotion is a fundamental right, and that has been violated, and this honorable court has also upheld that. I will refer to two paragraphs, lordships. This was the submission, and basing on this submission, order has been passed. Paragraph 11. Mr. T.B. Jamir, learned senior additional advocate general, of course, he was appearing as a counsel only, for the respondent number 1 and 2, submits that the petitioners do not have any locus standi to file the writ petition, inasmuch as none of them were eligible to be considered for promotion. This point may be taken note of, lordship. None of them were eligible to be considered for promotion to the post of additional secretary at the time of filing the writ petition. He submits that petitioner number 1 did not have the requisite length of service under the rules of 1999 as amended in 2012 for promotion to the post of additional secretary. The petitioner number 2 is due for superannuation in November 2023, and being the junior-most officer in the post of deputy secretary, and considering the remaining years of service left before his superannuates, he does not have the length of service left to be eligible to be considered for promotion. This is to be considered for promotion to the post of additional secretary. Similarly, the petitioner number 3, who is the post of under secretary, will be due for superannuation in 3 years' time and will not be having the length of service required for being considered for promotion to the post of additional secretary. Lastly, the petitioner number 4, who is the senior-most section officer and having 7 years service left before the superannuation, also does not have the required length of service left in order to be considered for promotion to the post of additional secretary. In fact, during the pendency of the writ petition, she has been promoted to the post of under secretary, with notification so and so. T.B. Jamir submits that it is a well-settled principle of law that only a person aggrieved can invoke the writ jurisdiction under Article 226 of the Constitution of India for the enforcement of his constitutional rights. As none of these petitioners at the time of filing the writ petition were eligible to be considered for promotion to the post in question, none of their constitutional rights have been infringed, and therefore they have no locus standi to file their writ petition. Earlier litigation was all about effecting the right to be considered for promotion, which is a fundamental right. And on this point, this honorable court has already given the verdict. And then paragraph 13, this is his submission. Consequently, a direction was issued by this court, and in compliance with the same, the Office Memorandum of 1/11/2021 restructuring the cadre of the upgraded post held by the respondent number 3 was passed by incatering the same to the third schedule A of the rules. Accordingly, notification was issued regularizing the services of the respondent number 3 against the sanctioned post of additional secretary. This shows that she was not holding a sanctioned post. So, by notification of 1/11/2021, she was brought to a sanctioned post. The said exercise having been done by invoking the powers conferred upon the respondent number 1 by Article 187 of the Constitution of India, and also under Rule 19 and 22 of the Rules of 1999, as amended in 2012, may not be interfered with by this court. Now, this order of 1/11/2021 has been issued under Article 187. That was the submission in the earlier litigation. And my learned friend, Mr. Takamasa, has adopted that submission. Kindly see paragraph 14, page 59. Paragraph 14. Mr. Takamasa, learned senior counsel, submits that he adopts and relies upon the arguments made by TV Jamir, learned senior additional advocate. Therefore, at one point of time, he has submitted that, look, earlier order of 1/11/2021 was passed by the speaker by invoking Rule 19 and 22 of the rules, and not Article 187. Therefore, this honorable court has interfered with. But he has adopted the submission of my learned friend, who was representing the respondent number 1 and 2, who made the categorical submission that this order of 1/11/2021 has been issued by invoking the power under Article 187. And that has been adopted by the counsel for the respondent number 3. And thereafter, the order has been passed. He has adopted the submission. And this order has never been challenged. Lordships.
Make it short.
Yes, I'm just concluding, Lordships. So, till today, they have been singing the same old song. In the earlier litigation, violation of fundamental rights, and then all this notification of 1/11/2021 bringing to the cadre was the issue that was decided. Even here also, the same issue and the same submission is being made. So, singing the same song on the earlier occasion, this honorable court categorically said that no, this song, they were saying, this song is relevant to be sung on a birthday. This honorable court said that no, this song is relevant for funeral service. In a similar form, what this honorable court said that no, this is relevant only for this, but then by circumventing the court order, they are coming and doing the same old thing. Therefore, Lordships, this is highly questionable. And so far as the rights of the petitioners are concerned, we are governed by one service rule, and our rights flows from the service rule. Those rights have been violated, and right to promotion is not a fundamental right, but at least a right to be considered is a fundamental right. And in the earlier litigation, that is 323 of 2021, our rights to be considered for promotion was violated. That was the issue, and this honorable court has said that yes, rights of the petitioners have been violated. Therefore, the notification of 1/11/2021, by which the respondent number 3 was brought together, has been interfered with, quashed, and set aside. And by the new amendment, they have done the same thing by circumventing the court order. Therefore, Lordship, it is a fit case to be interfered with by this honorable court. Our fundamental rights have been violated. Therefore, when fundamental rights are violated, this honorable court should interfere with the action of the respondents, Lordships. So, and so far as the decisions are concerned, Lordship, heading for which purpose, for what purpose we are referring, due to paucity of time, I'm not reading, but I'm furnishing the list. And all those judgments are very important so as to counter the judgments which my learned friends have given earlier.
Would you kindly grab in 5 minutes?
Lordships,
New fact has been raised. I want to clarify. I'll not take more than 5 minutes.
Now, which facts?
On my Lord current charge. Just one line clarification. I'll not take, Lordship can stop me if I go beyond 5 minutes. My Lord, on the issue of current charge, this is a subject matter of the other in the writ appeal. So, my Lord, so my Lord, current charge should not be brought into the submission of my learned friend. My Lord, that should be brought in the present case because he has challenged the current charge, which is the subject matter of writ appeal 28, which is in the other case. That is one I would like to make a submission because we should not, this honorable court should not interfere in that particular point. One. Secondly, Lordship, my learned friend has made a categorical submission that since he have no grievance against respondent number 3, I was not impleaded as respondent number, I wasn't impleaded as a party in the case. That was his statement. My Lord, Lordship may kindly take note of that, his categorical submission. And finally, Lordship, this is a case, subject matter of the case is amendment of the rules, nothing more, nothing less. And Lordship, the Dr. Ashwini Kumar's judgment. My Lord, as a reminder, it says the basis of the judgment can be changed by the legislature.
Lordships, I have left out one.
For both of us.
Lordships, yesterday Lordships was asking me one pointed query. That since my learned friend has referred to some of the complaints lodged by some of the employees, or whether all members are, all the members of the association are not supporting the amendment, that pointed query Lordship has put to me. So I would like to clarify that point, Lordships. After the amendment was met, a meeting was held. The members of the association, a meeting was summoned. And on 23rd May 2022, a resolution was adopted. Members who were present in the meeting have also endorsed their signature. I'm just placing the resolution of the meeting, and the president was entrusted to file the writ petition, and the attendance of the members are all enclosed.
My Lord, it may be an afterthought. It was not
I have-
enclosed in the writ petition
No.
or in the pleadings.
I'm just responding to the
Kohima,
query
which is not
made
an
from this
ex-
honorable
support-
court. My learned friend should not disturb. I have not disturbed him.
No, I've seen this document.
That is one. Dates are very important, Lordship. Considering the high politics involved in this case. Yes, it was on 23rd. Basing on the resolution, writ petition was filed on 25th May. Meeting was on 23rd. Resolution was taken.
That should not be accepted because he has not mentioned the time, 23rd, odd time.
Yes, nothing in the pleadings has to be looked into, Lordship. Pleadings. Pleadings is not, pleadings, pleadings.
I've got the,
Pleadings has to be looked
how
into.
about your written argument?
Yes, it is. In the afternoon, I can furnish, Lordship.
Afternoon.
Yes. It is under tidy. Now, meeting was on 23rd May.
There's a limit.
I am just responding to the query made from the honorable court.
Okay. I've
And
seen
if
it's on 23rd May.
that query is not required to be answered, then I can stop. But I'm responding to the query made from the honorable court. And the writ petition was filed on 25th May. And then the complaint was submitted on 4th June 2022. 4th June. Subsequent, members are there who are present, but after the amendment, respondent number 3 was given the current charge. So she is the secretary, administrative authority. Under her, all the employees are working. We are working under her now. And this is an afterthought. Therefore, Lordship, my only prayer is, this is a ploy to frustrate the ongoing litigation. Just in order to frustrate the writ petition, this complaint has been filed by some vested interested person, maybe at the behest of the respondent number 3. Therefore, Lordships, my only prayer is, considering the seriousness of the issue, it will be too remote to connect with the issue, with this issue, so as to decide this case.
TB, on the operation of law with regard to the deregistration.
No, just Lordship, the other day I submitted your Lordship. Here the issue involved is mostly the interpretation of the section 3A1 and section 5, whether each section 5 can be read in isolation. So going as per section 3A1, your Lordship, on expiry of the validity period, so by operation of law, that is my submission. Their license.
Okay. Heard census.
Lordship, the other cases also.
The other case, we'll list it after disposal of this.
Very well, Lordship.
This is in the writ petition. So and so. Hearing concluded, judgment reserved. And in the writ petition, writ appeal, that is 28th of 2022.
Lordship, may kindly record that the reasons, we have submitted written submissions. Will you kindly put that on record?
Petitioners, are you sure you are submitting?
Yes.
Okay, the written arguments on top, you say, furnished by the petitioner, respondent 1 and 2, and respondent number 3 are taken on record. And in the writ appeal, you say, list this appeal after disposal of WBC 92 of 2020.
Yes.
This. Pardon? We come to the
Yeah, please, Your Lordship.
Yes, please.
Lordship, I'd like to mention item number 3 on behalf of Madam Lucy, Lordship.
On behalf of?
Madam Lucy, Lordship.
Yes, please.
Lordship, here, she's yet to receive instructions, so if this matter can come up after the election, Lordship.
Yes.
Your Lordship, I'm for the petitioner.
Yeah.
Attila Pungin.
Heard Ms. Attila Pongan and counsel for petition. On request made on behalf of Ms. Lucy Leonard, senior government. How much time?
3 weeks,
3
Lordship.
weeks time is allowed to file counter affidavit. List according. Yeah.
Obliged, Lordship.
Oblige, Your Lordship.
For motion, item number 1.
Yes.
May I please, Your Lordship?
Where's the application?
On Annexure D, page 15. And Annexure C, page 14. My lord. Annexure D, page 15, my lord. Annexure D. On
What
page
date?
15.
What date is this? This school education department.
Yes, my lord, Education Department.
Oh, then I better not take up. List this case before any other bench without put my. Tomorrow, Monday will come up.
My lord, I'm filing for nomination in the coming election, so I have filed my leave of absence. May fix on date 10.
I can't give a date because I can't take up the matter, school education. So next date when it comes up, you can seek for another.
For admission, item number 2.
Yes,
This is for admission hearing, Your Lordship.
yes, Longuma. Today may be difficult.
My lord,
Today will be a little difficult.
as per the last order, it was fixed today for admission hearing. The Union of India, they are yet to file affidavit. But as per the last order of 22nd November 2022, it was directed that if no affidavit is filed, the Union was directed to file affidavit on or before 25th of January. And then failing which, the matter will be heard on the basis of the documents available.
Heard Mr. N. Longkumar, learned counsel for the petition. Also heard Mr. N. Angami, learned government advocate for the state of Nagaland. Stop. None appears for Union of India. We will fix a date or after 1 week.
You can fix a date. Lordship, after a week, Your Lordship.
List the matter after 1 week. On the next reasonable date, if the Union of India is not represented, this case shall be proceeded ex parte against, against them.
Obliged, my lord.
Item number 4.
Please, Your Lordship. Your Lordship, my senior is on the way. Kindly wait for a few minutes.
Item 5.
Item number 5.
Lordship, is the response ready to file counter, Your Lordship?
Yes.
Lordship, I'm appearing on behalf of Tipa, Lordship. If 3 weeks may be granted, Lordship.
Heard Pongwati Waling, learned counsel for petition. On request made on behalf of Mr. Tipa, Home learned government advocate. 3 weeks time is allowed to file counter affidavit. List according.
Your Lordship, interim may be continued, Your Lordship.
Interim order passed earlier to continue till the next meeting.
Obliged,
Obliged.
Lordship.
Item number 4.
I can't wait.
Your Lordship, kindly wait for a few minutes.
My court does not wait. On request made on behalf of MSZ Zimomi, learned counsel for petition. List after 1 week.